Good afternoon, everyone. We will now continue the discussion in Chapter 2, Obligation of the Partners. So, under in this chapter is legal relations created by a contract of partnership. These four distinct juridical of partnership are the relationship that will be created upon executing a contract of partnership. The first one is relations among the partners with the partnership, meaning what are these obligations would arise in executing a partnership with respect to his or her partner. We have to know the nature of the partnership with a fixed term or a particular undertaking and the partnership at will. The obligation of each partner to each other and foremost obligation is the obligation to observe good faith or fiduciary duties to their co-partners. The second one, relationship, is between the partners with the partnership. Note that partnership itself has a separate juridical personality. So there is a relationship between the entity of the partnership and the partners. The third one is relations of the partnership with third person with whom it contract or who will enter into obligation with. The fourth one is relation would be the relationship between partnership with such third person with whom the partnership has contracted. Let's say, for example, A and B entered into a partnership, AB partnership, and um, both partners managing um, another two partners na pumasok sa contract din nila. And for number one, the example would be relations between A and B. The second relation of the partners with the partnership, relation between A and B on one hand, and on the other hand, we have AB partnership. The third one is relations of the partnership with third person with whom it contracts. So let's say, for example, relations between A and B on one hand, and on the other hand, we have C and D. The fourth one is relation would be the between partnership and with such third person. So, for example, relations between AB partnership and C and D. So, yun yung mga example nun. Partnership relationship, one of mutual trust and confidence. With fiduciary relationship, fiduciary duties, remember that being in this relationship involves the utmost good faith and trust and confidence remains until partnership is terminated. Rights and obligation of the partner, dito yun sa ating third slide. First obligation with respect to give their promised contribution of property, of course. The first duty is to contribute what has been promised. Note that the parties in a partnership obligate themselves to contribute money industry to a common fund with the intention of dividing the profits among themselves. Under Article 1786, every partner is a debtor of the partnership for whatever he may have promised to contribute. He shall also be bound for warranty in case of eviction regard to specific and determinate things which he may be have contributed to the partnership in the same cases and in the same manner as the vendor is bound with respect to the vendee. He should also liable for the fruits thereof from the time they should have been delivered, without the need of any demand. Now, in case that person fails to contribute, the remedy is not recession but specific performance with damages in interest. The second obligation, not to convert partnership money to their own use. Consistent with the first obligation, it is a duty of a partner to contribute on due date the amount which he promised to give. This is also following Article 1788. A partner who has undertaken to contribute a sum of money and fails to do so becomes a debtor of the interest and damages from the time he should have complied with his obligation. The same rule applies to any amount he may have taken from the partnership's coffers, and his liability shall begin from the time he converted the amount of to his own use. So and the liability of the partner to contribute that money, it arises from the commencement of the partnership unless it is otherwise stipulated. Added in second obligation would be the duty to reimburse any amount which the partner may have taken from the partnership coffers and converted to his own use. He got money and used it to buy something for his personal use. Yung partner nun magiging ano siya, liable siya sa amount, and the liability begins from the time that he converted that amount to his own use. The right of the partnership in this case is entitled to demand only the amount converted, the interest, and the damages. Pero yung partnership nun, hindi siya avail dun sa profit na na-derive ng partner from the use of the converted funds. Another one is it includes the duty to pay the agreed or legal rate of interest in case of failure to pay out the amount that the partner promised to contribute in due time. There's also the duty to indemnify the partnership for damages which is caused to the partnership due to the delay in giving the contribution. Another pointers dito is under ng second obligation, included dito yung duty to pay the agreed or legal rate of interest, pay the amount that the partnership promised to contribute in due time. And there is also the duty to indemnify the partnership for damages which is caused to the partnership due to the delay in giving the contribution. It is clear that the partnership who undertakes to contribute a sum of money and fails to do so is already in default. He now becomes a debtor of the interest and damages from the time that he should have complied with of his obligation. In demand ba dito is necessary? The answer is no. Bakit? Because demand is not necessary to place him in default. Why is that? Because the interest and damages accrued by operation of law, the double responsibility for interest and damages is because it's for the reason that every partner is responsible to the partnership for damages suffered by the partnership through the fault of that partner. Third obligation, to account and hold as trustee for any profits derived without the consent of the other partners. Ito ay under siya sa Article 1807. Every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conflict, or liquidation of the partnership or from any use by him of its property. This article, of course, refers to only profits derived by a partner without the consent of the other. But still, yung partner dito is accountable as fiduciary because the relationship involves trust and confidence. Each partner is considered in law as confidential agent of the others. Fourth obligation is not to engage in any business which is of the kind in which the partnership is engaged. As for this, remember there are rules in industrial and capitalist partners. An industrial partner contributes his service or his industry to the partnership, in which case he has to devote his time to the business of the partnership. As such, the industrial partner cannot engage in any business for himself unless the partnership expressly permits him to do so, or if the parties agreed. If the industrial partner engage in a business, for example, industrial partner is a mechanic and the partnership is a car repair shop, can he put up story can he put up store selling drinks? Of course, no. He cannot do that because any business at all is prohibited. Why? Because he needs to devote his time and effort to evaluate his performance of his industry. The purpose of this rule is to prevent a conflict of interest and to ensure compliance by the industrial partner who must devote his time to the partnership. This rule is under Article 1789. The rule in capitalist partner is not much pressure but a little more relaxed compared dun sa industrial partner. As simply prohibited from engaging in operation of a business which is of the same or similar kind in which of the partnership is engaged. If the partnership is selling papaitan, he cannot sell sisig. That prohibition, it carries an exception as the capitalist partner may be allowed if there is a stipulation to the contrary. The other partners expressly agreed in writing and what is best to determine if there is a conflict in interest, then the test is simply if there will be unfair competition. Tandaan na yung partner occupies a fiduciary position imbued with trust and confidence with respect to his co-partners, and this imposes duties of utmost good faith. Therefore, the violator know the partner who violates these rules can be out from the firm on the ground of loss of trust that will turn to lead to dissolution of the firm. The fifth one is obligation of managing partners to credit to the partnership the payment made by debtor who owes them and the partnership. So here, where the person, the debtor, is separately indebted to the partnership and to the managing partner at the same time, any sum received from the debtor should be applied to the two credits, the partnership and the managing partner in proportion to their amounts. Even though the managing partner gives a receipt for his credit only. This is under Article 1792, and there is a time that this can be only applied for payment in full or the debt in full, where managing partner receive it entirely for the partnership, not for himself, but the priority is for the partnership that the whole sum shall be applied to the partnership credit only. Remember that partnership takes priority over the personal affairs of the managing partner, and the purpose of this rule is to protect the interests of the partnership from being subordinated to the personal interest of the managing partner. Sixth obligation, obligation to share with the other partners the share of the partnership credit which they have received from an insolvent partnership debtor. In case of a partner who received his share in the partnership credit, he shall be obliged if the debtor becomes insulted. The partner will be obliged to bring to the partnership capital what he has received, even though he may given a receipt only for his share. He has to give it to the partnership applying the fiduciary duties. Partner will prioritize the interest of partnership. This is under Article 1793. This will also be discussed by the following reporters. He or she will present to you the difference between the fifth obligation and the sixth obligation. Makikita yun sa libro yung pinagkaiba nung fifth at saka nung sixth obligation, yung 1792 at saka nung 1793 articles. Seventh obligation, pay for the damages suffered by the partnership through their fault. This is known as the duty of diligence under the Article 1794. Every partner is responsible to the partnership for the damages suffered by it through his fault, and he cannot compensate them with profits and benefits which he may earn for the partnership by his industry. However, the courts may equitably lessen this responsibility if through the partner's extraordinary efforts in other activities of the partnership, unusual profits have been realized. If the partner cannot compensate the partnership with the benefits and profits which he may have earned for the partnership by his industry, that is he cannot do. Every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot say no that he is not liable for that damages. And he will only pay for what he received, and your benefits and profits will also pay by him. The law expressly say that he cannot compensate the partnership with the benefits and profits which he may have earned for the partnership by his industry. Let's go now for the fourth slide. We have the rights of partners. The first one is right to associate with another person in their share, also known as contract of subpartnership. This is under Article 1804, and the contract to subpartnership is one form between a member of a partnership. For example, Mr. Moon, Mr. Lee, and Mr. Enrile are members of partnership, and Mr. Enrile is a partner as stated. Then Mr. Chavez will agree with Mr. Enrile. Then Mr. Chavez will be the sub partner of Mr. Enrile. Ayan, di ba? May tatlo tayong taong binanggit. Mr. Moon, Mr. Lee, and Mr. Enrile. And then meron pang isang another sub-partner na which si Mr. Chavez. Ngayon, si Mr. Enrile, he have contract with Mr. Chavez. So, meron tayong another sub-partner. Kaya lang, si Mr. Chavez ay hindi siya makakasama sa partnership nila Mr. Moon, Mr. Enrile, at saka ni Mr. Lee. Na-discuss to nung previous reporters. So, yung tatlong yon hindi kasama si Mr. Chavez no, kasi kay Mr. Enrile naman siya nagkaroon ng agreement. Hindi dun sa partnership ng tatlo, pero kay Mr. Enrile lang siya nagkaroon ng agreement. That's the one form between a member of partnership and a third person for the division of profits owing to the members of the partnership form the partnership enterprise. It is like partnership within the partnership. So separating from the main or principal partnership. So a partnership is may another partnership. Second right is right to have access to and inspect and copy partnership books. Remember that there is obligation on the part of the partner. In the case of the duty of the managing partner or the partner who is assigned, as they have the duty to keep the true and correct records in the books, showing accurately the firm's account, and these books should be open to inspection at all times with reasonable hours on business. If there is a duty to keep books faithfully, then there is a right to inspect the book. This right may not be absolute since the partner may restrain from using the information gathered in which he used this for purpose in conflict with the partnership purpose. Of course, yung partners nun, syempre may knowledge dun about the actual state ng account. Third right to demand a formal account. Generally, a partner is not entitled to a formal account of partnership affairs during the existence of a partnership because aside from being inconvenient and possibly a waste of time, the right to know such affairs are already protected by Article 1805. The partnership books shall be kept subject to any agreement between the partners at the principal place of business of the partnership, and every partners shall at any reasonable hour have access to and may inspect and copy of any of them under Article 1806. The partner shall render on demand true and full information of all things affecting the partnership to any other partner or of any partner under legal disability. So this formal account is usually proper only as necessary incident of dissolution. When a partner asks for dissolution, he also asks for formal account of the partnership affairs. But under Article 1809 gave us formal account may be demanded, namely first a partnership, if a um if a partner is wrongfully excluded from the possession of its property by his co-partners, wrongfully excluded. Second, if the right exists under the terms of any agreement. Third, provided by provided by under Article 1807, partners from any transaction connected with the formation, conduct, or liquidation of the partnership, or from any use by him of its property. And the last, whenever other circumstances render is just and reasonable. Ano ba? Fourth right is right to ask for the dissolution of the partnership at the proper time. This is under Article 1830 to 1831. So anytime can be dissolved by the anonymous agreement of partners. This will be discussed by the future reporters. The fifth right is property rights of the partners. So may tatlo tayo dito. Rights in specific partnership, interest in the partnership, right to participate in the management. So property is different from capital, which is contributed. The property or asset is variable wherein the value may change as the market value likewise changes, and the property, when we talk about property, it can include goodwill or it can be include the capital itself. The value of capital is always constant because it is fixed in the articles of partnership or in the contract of partnership and may consist of money, property, or industry. Under this property, nabanggit natin, the first one is right in specific partnership property. This is the tangible property that is belong to the partnership. Since partnership has a separate juridical personality and distinct from the partners, this means that the partners have no actual interest in the partnership property until after the partnership itself dissolved. Remember that under Article 1811, a partner is considered a co-owner with co-partners over a specific partnership property. As a result, co-ownership, there are certain incidents. First, we have the right to possession. Each partner has an equal right with his co-partners to possess a specific partnership property for partnership purposes. He has no right to possess that property for any other purposes without the consent of his partners. And if his partner uses that property for his own profit, then he must account to his full partner for the said profit. Second incident is that partner cannot assign his interest in any specific partnership property because the individual partner have no specific interest in the specific partnership property which belongs to the partnership. It is also preserving the interest in the property after liquidation. It protects the rights of the partners and the partnership creditors to have the partnership asset applied to the firm's liabilities or debt, and this will prevent interference by outsider partnership affairs. Another incident of this property of co-ownership is that the specific partnership property is not subject to legal support because the partner does not own the property that belongs to the partnership, and only the partner's interest in the legal partnership that may have subject to legal support. The last is the partner's interest is not a debt due from the partnership, and there is no credit, debit, or relationship. The second one is interest in the partnership. It is referred to the partner share in the profit. The excess of partner returns over expenditure in a transaction or series of transaction and the partner share in the profits and the surplus. Surplus refer to the asset of the partnership after its liabilities paid and the rights of the partners among themselves are adjusted. The third one right is the third one right under the property rights of partner is participate in the management, right to take part in the management dealing with external parties similarly to decision making and control. Fifth slide. Article 1784, a partnership begins from the moment of the execution of the contract unless it otherwise is stipulated. So it is a contract relation if the contribution of the partners to the partnership have not been made, the form of the partnership already exists. The partnership is a consensual contract. It exists from the moment of the celebration of the contract by the partners. However, this may be stipulate that the partners agree on some other date to begin their partnership for the commencement of the partnership relation. A partnership may have unlimited duration, unlike in old corporation law. In partnership, there is no limit set for the existence of it, and the parties may stipulate agree on a specific term. If the partnership is a fixed term, if the partnership is a fixed term or particular undertaking, then the term has either expired or the undertaking has been completed and the business continued without any express partners remain the same as they were such in termination. So, yung rights and duties ng partners remain the same dun, without any express of agreement. So, far as with consistent with the principle of being a partnership at will, this is under Article 1785. Ito yun. Ito na yun. Under Article 1785. Ito ba yun? Ay, ito pala. (1785). Ay, ito. So, example natin dito sa Article 1784 when the two partnership celebrate their moment of execution of the contract, for example, February 14, 2021. The life of their partnership begins on February 14. Pero, sinabi nga kanina, however, this may stipulate that the partners agree on some other date to begin their partnership. So, pag-usapan nila na yung contract nila is hindi sa 14, parang commencement of their contract of the partnership will begin on April 17. So, yung April 17 na yung magiging, magiging life of partnership, hindi na sa February 14. Yun na pag-usapan. April 17, hindi na sa February 14. Yun yung agreed date, not on July, not on February, but on April. Nabanggit din dito yung yung last report na prima facie evidence. It is to establish a fact or to raise a presumption of fact unless rebutted. If the partnership agreed on a term of undertaking, the expiration of the term or the accomplishment of the undertaking will cause the automatic dissolution of the partnership. And if the partners continue the business, then the partnership with a fixed term is dissolved and the new partnership is created by implied agreement which is partnership at will. Bagit din natin dito. Saan yung partnership will? This fixed term. Next na pala yun, next reporter. When a partnership created, there are several relations in that contract which was discussed a while ago, yung apat na juridical partnership. So here in executory agreement of partnership, overall it can predict on the mutual desire and consent of the parties. In effect, its registration in the Security and Exchange Commission is not essential to give juridical personality. A partnership, in fact, cannot be predicated on an agreement, in fact, cannot be entered into a co-partnership at a future day unless it is shown that such an agreement was actually consummated. Here in 11th slide, which is continuation of partnership beyond fixed term. Partnership with fixed term, one in which the term of its existence has been agreed upon impliedly. It may be extended or renewed by co-partners express implied agreement. In such case, yung rights and duties ng partner remains the same. With continuation and the partnership for a fixed term or particular undertaking is dissolved and the new one is created. Partnership for indefinite term, an undertaking that the relation shall continue while accomplishment of a particular undertaking, and partnership with mere expectation such a hope does not establish even by implication a fixed term or a particular undertaking. So ito yung mga under nun, continuation of partnership beyond fixed term, rights and duties of partnership, partners in a partnership at will, dissolution, termination, and the power right of to terminate partners. That's all po. Thank you.